Today's podcast is brought to you by Audible.com. Get a free audiobook download and 30-day free trial at washingtech.com/book. Over 180,000 titles to choose from for your iPhone, Android, Kindle, or MP3 player.
Moving the needle. Welcome to the Washington Policy Podcast.
Curating communications, media, and tech policy news so you don't have to. News, interviews, everything you need without the axe to grind. It's the Washington Tech Policy Podcast with Joe Miller.
President Obama includes cybersecurity and computer science in his new budget proposal. Congress votes to end internet taxes, and Ad van Loon is my guest. President Obama released his budget proposal last week, and he's looking for a 35% increase in cybersecurity funding, or about $19 billion. The president is also asking for $4 billion to teach computer science in schools. The Computer Science for All plan, which would fund states to teach coding to K-12 students. The funding would also go toward recruiting highly skilled talent to work for the federal government. The president also announced that he is directing the administration to implement the Cybersecurity National Action Plan, or CNAP. The plan would bring in leading thinkers outside the Beltway to make recommendations on improving privacy and public safety. It also includes a $3.1 billion proposal for an information technology modernization fund, which would fund a new White House role, the Federal Chief Information Security Officer, to help update the federal government's IT infrastructure. It also includes plans for public-private partnerships with companies like Google, Facebook, and Dropbox. You can view the executive order at whitehouse.gov. The Senate has passed the Permanent Internet Tax Freedom Act, or PITFA, and legislation now heads to the president's desk for signature. The law, which has wide bipartisan support, is a permanent ban on state and local taxes on internet access. The bill has wide bipartisan support. The FCC will hold its open meeting Thursday and will focus on a notice of inquiry seeking comment on programming diversity and obstacles independent programmers face trying to get their content distributed. The commission will also issue a notice of proposed rulemaking seeking comment on a framework for set-top box competition. And there will also be a second report in order on closed captioning, plus 3 enforcement actions. That's this coming Thursday, February 18th at 10:30 a.m. at the commission. Despite recent reports by Pew and the Joan Gantz Cooney Center concluding that the price of internet service is preventing many Americans from adopting broadband at home, the Republican-led House Energy and Commerce Communications Subcommittee has passed a bill intended to prevent the FCC from regulating the rates or prices companies charge consumers for internet access. The No Rate Regulation of Broadband Internet Access Act was sponsored by Republican Representative from Oregon, Greg Walden, and from Illinois, Adam Kinzinger. The House Commerce Committee also passed the Small Business Broadband Deployment Act, which would allow small internet service providers, those with 1,500 or fewer employees and 500,000 or fewer subscribers, to permanently waive compliance with the FCC's net neutrality rules. The Senate Commerce Committee Chair John Thune, the Republican from South Dakota, and Ranking Member Bill Nelson from Florida introduced the Mobile Now Act last week. Among the provisions, the act would provide a statutory mandate to implement the president's 2010 executive order to free up 500 megahertz of federal spectrum by 2020, promote dig-once policies so that broadband pipes are placed underground when municipalities undertake highway projects rather than having to tear the ground up again when it's time to deploy broadband, create an online portal showing which federal spectrum is available to private entities, and require the Commerce Department to issue a report within 18 months on what else can be done to speed up mobile infrastructure deployment. John Egerton has more over at Broadcasting and Cable. The FCC released its annual broadband report, which focuses primarily on its efforts to promote broadband by freeing up spectrum through the incentive auction. It also discusses its open internet order, efforts to update Lifeline to cover broadband, and its efforts to improve broadband capacity in schools via the E-rate program. You can find the report at fcc.gov. 80 House Democrats wrote to FCC Commissioner Tom Wheeler, urging him to ensure Lifeline covers all telecommunication services. The letter states, quote, "This would allow the consumers to elect which services best meet their individual needs, applying the subsidy as a credit," end quote. The FCC's Consumer Advisory Committee also issued a recommendation calling on the FCC to modernize the Lifeline program. Finally, we will discuss this issue briefly in my interview with Ad van Loon, but I just wanted to point out that Google has announced it will begin scrubbing its web search results accessed from European countries much more aggressively. In a nod to the right to be forgotten, if a European citizen asks for particular search results to be removed, Google will remove the search results from all of its servers worldwide, not just the server in the country in which the citizen resides. Stay with us. And for you, the listeners of the Washington Tech Policy Podcast, Audible is offering a free audiobook download with a free 30-day trial to give you the opportunity to check out their service. You'll be amazed at how much time Audible will save you. Why not listen at the gym, in the car, or in between meetings? How about The School of Greatness, a real-world guide to living better, loving deeper, and leaving a legacy by Lewis Howes? You can download The School of Greatness or another audiobook free by trying audible.com. Sign up for your free audiobook and 30-day trial today at washingtech.com/book. My guest today is Ad van Loon, a communications lawyer based in the Netherlands. And in 2008, he created the strategy consulting group X Media Strategies, where he has advised leading broadcasters, including the BBC, Deutsche Welle, Euronews, MTV, NHK, NPO, RAI, RTL, SBS, TV5, and TVE, and operators of electronic communications networks, including KPN, Tele2, UPC, and Ziggo, on rights management strategies and on distribution and jurisdiction issues in the EU. From 2008 to 2010, Ad coordinated a joint project of the EU and the Council of Europe on the promotion of European standards in the Ukrainian media environment. From 2000 to 2008, he was manager of legal and regulatory affairs at NLkabel, the trade association of cable operators in the Netherlands, and a member of Cable Europe's regulatory group. From 2001 to 2009, Ad was also an adjunct professor at New York Law School, where he taught courses on European Telecommunications Law, broadcasting regulation in European states, and European intellectual property law. He also taught European Telecommunications Law at the University of Sergio Arboleda in Bogota, Colombia. Ad lived in France for a while, where he worked at the Council of Europe. Before that, he worked at the Institute for Information Law of the University of Amsterdam. Ad's expertise covers media and acquisitions in the media and telecommunications business, copyright, personal data protection, and cross-border content distribution. In 2014, the Chinese government invited Ad to their first World Internet Conference in Wuzhen, where he held a presentation on why payment platforms will rapidly become redundant. Ad contributed to several studies on media and antitrust law for the Council of Europe, UNESCO, and the Dutch government, and to several studies commissioned by the European Commission on the implementation of European rules in the broadcasting sectors of the member states. He also has a long-standing expertise since 1989 in advising lawmakers in Central and Eastern European countries on how to create more democratic media structures. He studied law at Tilburg University. Please welcome Ad van Loon. Ad, welcome to the show.
Thank you.
Our topic today is data security and how U.S. data security laws compare with the European Union's. Recently, the European Court of Justice struck down the so-called Safe Harbor Agreement, which had for 15 years enabled U.S.-based tech companies to seamlessly access Europeans' data. This statutory regime is credited with enabling companies like Google and Facebook to expand worldwide. The safe harbor was created out of a presumption that U.S. data security laws were not sufficient for meeting the standards contained within the European Charter of Fundamental Rights. So the safe harbor was designed to allow tech companies themselves to take a more active role in protecting the data of U.S. citizens. However, the entire U.S. system of data protection was called into question beginning in 2013. That year, Ed Snowden revealed documents he acquired as a government contractor that apparently revealed top secret tactics the National Security Agency, NSA, carried out to spy not just on Americans, but also on citizens abroad, including heads of state like German Chancellor Angela Merkel. So those revelations were the beginning of the end of the safe harbor. And since the safe harbor was struck down last year, the U.S., EU, and tech companies have been locked in this battle around how to essentially merge U.S. and European data security laws so that there can once again be some sense of business as usual. Ad, I know that by the time we end in the next few minutes here, we will have solved the entire situation.
That is a challenge, but why not? Let's try.
So let's take a step back. Let's set the stage for us. Tell us about the EU's Charter of Fundamental Rights and how U.S. data protection laws differ in terms of their overall view of data protection.
The Charter of Fundamental Rights of the EU has two provisions, one for the protection of private life and the other one for the protection of personal data. And these are fundamental rights that have to be respected by the organs of the European Union. And since these are fundamental rights, personal data protection is very strong in Europe, and the Court of Justice of the European Union has to ensure compliance with these fundamental rights by the European institutions. And in the US, this is different. Protection of personal data is not a fundamental right. It's not a constitutional right as such. And that's where the difference is. And in addition, there's a different level of protection of EU citizens in the US compared to US citizens and legal residents. EU citizens have no standing rights in US courts to protect their personal data. And yet the European institutions have to ensure that companies respect those fundamental rights that I mentioned before.
So European citizens have to rely on the EU for any type of remedy when it comes to when they feel that their privacy rights have been violated. Let's look briefly at procedure in the EU. When an aggrieved party, a citizen, feels that his or her privacy rights have been violated, what's the first step they would need to take, and how would the case work its way up through the appeals process to the European Court of Justice, the highest court?
It's a complicated system in Europe because there is a division of powers between the member states and the European institutions. So the way it works, that if somebody, an individual, would feel that his or her personal data rights have been breached, have been violated by a company, this individual would first have to complain to the Data Protection Authority that is responsible for ensuring compliance with the European rules. We recently had the case of an Austrian student who felt that Facebook violated his fundamental right to protection of personal data because Facebook collected data from him and then transferred these data to the US. And this student felt that in the US, those data were not protected adequately.
And this was the Schrems case, right?
That's the Schrems case, indeed, Max Schrems from Austria. He had to complain to the Irish Data Protection Authority that Facebook obliges EU citizens to contract with their European entity, which is based in Ireland. And therefore, the Irish Data Protection Authority was competent in this case. The Irish Data Protection Authority felt that the Austrian student had an issue in this case, but on the other hand, felt not competent to take a decision itself for a reason that the European Commission had concluded an agreement with the United States, the Safe Harbor Agreement, and therefore the national data protection authorities could not overrule this decision. For this reason, the Austrian student, Max Schrems, took the Data Protection Authority to court, appealed the decision to the High Court in Ireland, and the High Court in Ireland addressed the Court of Justice of the European Union for guidance. This is an obligation under EU law that national courts cannot themselves interpret EU rules. If there's a question of interpretation of the rules, they are obliged to seek guidance from the European Court of Justice in Luxembourg. The EU Court of Justice assessed the matter and came to the conclusion that indeed the data protection in the US could not be considered as being adequate and overruled the agreement with the US on safe harbor. At the same time, the court referred the case back to the High Court in Ireland and said the national courts and the national data protection authorities do have competence in this matter, despite of the decision by the European Commission upon an individual complaint of a EU citizen.
So what are the economic implications of this, Ad? There was one report by the Boston Consulting Group that discussed the economic value of transatlantic trade. What were the findings of that report, and what's at stake if the US and EU don't figure this out?
It's about a lot of money. The report by the Boston Consulting Group is about the value of our digital identities. And it's a report that was compiled in 2012 and published in January 2013. It was commissioned by Liberty Global at the time. And the Boston Consultancy Group said that the exchange of personal data, the transatlantic exchange in 2012, had already a value of $50 billion US dollars. And the exchange of personal data, transatlantic exchange of personal data, had a value of already $250 billion. And they, at an annual growth rate of 22%, they expected the total value to triple to $1 trillion US dollars by the year 2020. But they also said that if the rules would be too tight on the exchange of personal data across the Atlantic, then it would decrease by 2/3, or an amount of $440 billion in 2020. So basically, the message was, if Europe prevents the exchange of personal data, then the value by 2020 is 440 billion euros less than it could be if there would be free trade, free exchange of personal data.
So on top of the safe harbor being struck down, when were the EU's new rules on data protection passed, and what are they?
The decision that we talked about before was based on the old rules in the directive of 1995. The new rules will be contained in a regulation that will have direct effect in the member states, and it's called the General Data Protection Regulation. It has not been formally adopted yet, although it will be this spring, probably at some point in time in March or April. And the purpose of these new rules, how they are different from the old rules, is that individuals will have more rights. For example, a right to be forgotten. That means that if a platform or a search engine refers to the individual's personal data, and the individual thinks that these data are not accurate or would like to have these data deleted, the individuals will have a right to ask the platform or the search engine to remove these data. That is one consequence. The other consequence is that individuals should be given easier access to their data upon request. They should give access to their data wherever they are stored, by their salary administration, their insurance company, their bank, by an internet platform. Then they will have the right to know where their data are stored and for which purposes. Transparency will be a major issue. What is happening to their data? They should know, they should be informed about that. They will have a right of data portability. That means that if they subscribe to one platform and they want to take the information that they uploaded to another platform, they should be entitled to do so. This should be facilitated, and in a simple way, in machine-readable format, so that it can go from one provider to another provider automatically. Then data protection by design and by default will be implemented. All services will have to offer will have to be designed in such a way that the starting point is the protection of personal data. And there will be stronger enforcement rules. That means that companies who do not respect the new rules can be fined up to an amount of 4% of their global turnover, with a maximum of, if I remember correctly, 20 million euros. So these are all changes, new elements compared to the present day rules. And they will also apply to third countries, providers in third countries, for example, the US, if they seek to offer services to EU citizens. So that's a broad summary of the new rules.
And so how will these rules affect U.S. companies? When do they take effect? What can U.S. companies do to avoid violating the rules? What if they do violate the rules? How is this going to work in the U.S.?
Well, first of all, the new rules won't take effect for a while because, first of all, they have to be formally adopted, which will happen this spring. And then there's a 2-year transition period, so there is some time to adjust. But the new rules will apply to all companies, all organizations that seek to offer services to persons in the EU. So the new rules will not apply if a person from inside the EU visits a website in a third country, but if this website or this platform aims at offering e-commerce services or other services, or collects personal data or tracks persons inside the EU, at that moment, the new rules will apply. And these companies will have to obey the new rules.
And what about a conflict of laws? How will those be resolved?
This was a major issue of the negotiations that have been ongoing since the Schrems judgment. And there was a meeting on the 2nd of February between the US and the EU in Brussels, where they tried to resolve the issue. And the press release says that they have managed to resolve these jurisdiction issues. And this is still subject of consultation with the data protection authorities in the different EU member states. And then Congress will probably have to find something, discuss the matter. But the basic principle is that the US is seeking to give more protection for personal data of EU citizens, and that there will be some sort of ombudsman in the US to which EU citizens can address themselves once they feel that their personal data rights under EU law are not protected adequately in the US.
And it's been an absolute pleasure having you on the show. Now I want to shift the conversation and ask you a few more questions about your success factors. It's something I always like to do. So we'll do that and then we'll close. Sound like a plan?
That's a good plan. Yes, please.
All right. This podcast is about policy, but it's also about what makes successful people tick and what we can learn about what constitutes success in the intellectual and policy spheres and how to generate a greater sense of fulfillment from our work. So how about you, Ad? What are some things, and they can be apps, tools, habits, or tactics that you use to stay on top of your game?
Well, I think first of all, you can only be successful if you have a passion for a certain topic and you really want to change things or to achieve a certain goal. What I personally try to do is I try to stay on top of new developments by using the internet, reading newspapers, but most of all, through networking and contacts, relationships, so that you know at first hand what is going on, or that you can easily check if you read something in the newspaper or on the internet, whether or not it is accurate, because it turns out in most cases not to be entirely accurate. So checking, having the sources to check, contacting primary sources, create a network, have good relationships, that's the first thing. Apart from passion that you need to have to be successful, I think.
And what's one book you're recommending these days to basically everyone you meet?
I think I would recommend the book that I'm currently reading, and it's very topical in the light of what we discussed. The book is called The Circle, and it's written by Dave Eggers, and it's about a lady who applies for a job at a global internet company. And this internet company tries to control everything in everybody's private lives. And even politicians, they convince politicians that they should go what is called transparent. That means that 24 hours a day, everything they do can be viewed by persons, internet users all over the world. so that there can be no secrets, no hidden deals. Everything is fully transparent, and there's a story developing around this and about the consequences, and it's very interesting.
All right. Well, Ad, thanks once again for joining me. Are there any final thoughts you'd like to leave with the audience, and where can folks find you online?
In terms of final thoughts, I think we should go back to the presentation of the Boston Consulting Group presentation in 2013 in Brussels, where the U.S. ambassador to the EU at that time, Bill Kennar, said that the U.S. would like to see the development of a transatlantic digital single market based on the same rules and the same level of protection. And I think that would be a noble goal to work on, because the current issues all arise from different approaches and different jurisdiction, different competences. And if we could find a way to harmonize this, that would solve many problems and promote business in transatlantic data flows. So these would be my final thoughts. And people can find me on xmediastrategies.eu and on Twitter at Ad van Loon, and on LinkedIn under the same name, Ad van Loon.
Ad, thanks again for joining me.
Thank you very much, Joe, and thank you for having me.
That concludes episode 26 of the podcast. Thanks so much to all of you for listening. I cannot do any of this without you, so thank you. If you're new to the podcast, or even if you've been listening for a while, I invite you to subscribe to the weekly Data Points newsletter, which is a summary of relevant communications and media-related research that's been done recently, as well as related socioeconomic research. You can find the sign up for that at the top of the page at washingtech.com. Thanks again to all of you for listening, and I will see you back here next week. Take care.
Thanks for listening to the Washington Tech Policy Podcast. You've been briefed.